And then the litigation proceeded that they wanted damages, not just merely that what they were out, but whatever else they might have been. And it was argued vehemently, I'm guessing, to judge from the nature of the opinion, the Supreme Court opinion, that at the trial court the differences were too great. They had to be much closer in similarity. The Supreme Court pointed out that nobody had alleged that the class representatives were not capable of representing and protecting the interests of all of the other people. They were merely different from what the other people were, but the same was true of everybody else. Is it really better to have 4,461 separate cases? And the Supreme Court said, no, you should not do that. It is dying. You needed to actually have some evidence that they couldn't fairly protect. The court found no evidence on that point, merely differences. And the discussion, commonality of interest doesn't mean identical interests. And that seemed to occupy a fairly significant amount of time in the case. And the court just basically said, one suit is a fairer, more efficient adjudication than 4,461. And that seems to make some good sense. But it was an interesting discussion to me in my life to have a discussion about what commonality actually would mean. Now the next two we're going to talk about are found on page 1 and page 2 of my materials. The first one is American Express versus Italian Colors. In that particular case, both of these are actually arbitration cases, but it concerned the ability of the arbitrator to have class action lawsuits. We all have arbitrations in commercial agreements, business agreements, so I think these two cases are instructive for us on the state level. The first one that we talk about was American Express versus Italian Colors. Now that was really a contract dispute. American Express is an expensive credit card for the merchant who accepts it. The fees that they have to pay, the clearing fees, the processing fees, far exceed the fees that any other credit card is to process. They alleged that this was a restraint on trade, and they wanted to have a class action. Now, in the agreement between the parties, there's an arbitration agreement, and it has a waiver. And it purports to waive the ability to have a class action arbitration. I'm sure some of us have seen that very same waiver. The question was whether that really was enforceable, or was there some judge-made rule that could be carved out, or perhaps even already existed, that could allow the arbitration to go forward. Well, it got to the Supreme Court, and the Supreme Court said, well, yeah, this is all a good argument. So what if you're going to have to spend $1 million just for experts to bring a claim that's worth a few $1,000s? Even if they prevailed and got trouble damages, the amount of the claim would be under $40,000. And the Supreme Court said, yeah, well, you contracted for that possibility, guys. So everybody who's wanting to take on American Express, you got to do it one at a time. Effectively, in my mind, probably killing any possibility of going after American Express. How many other credit card companies would amend their agreements to insert a similar type of provision? I presume those are coming if they're not already there. But the court expressed very little sympathy with the argument that, well, this isn't a cost-effective remedy. And if it's not cost-effective, it's not really a remedy. The Supreme Court said, well, a remedy is a remedy. Whether you can afford the remedy is a separate and unrelated question. And the fact that you can't afford your remedy isn't our problem. It's not a problem for the arbitrator. It's a problem of contract. You could have gotten around it, or at least made the effort to get around it by just negotiating it in your negotiation system. But unfortunately, for all of the people who would have hoped to have gotten on there, they're going to have to do them individually. So they're out of luck. And apparently they've gone through a done research as to what the comparable fees would be, and what the extortion rates were alleged to be was less than $13,000 over the time period covered. So it was a small amount. They're just out of luck. The other case where it arose in arbitration is kind of a cautionary tale to everybody who deals with arbitration. In that one, again, it concerned the authority of the arbitrator. In this case, the parties had, again, an agreement on arbitration. And it was agreed that the arbitrator should decide whether the arbitration agreement allowed a class action arbitration or not. The arbitrator was chosen, everybody agreed on the arbitrator. And it all fell apart when the arbitrator came back and says, well, yeah, class action arbitration is permitted. That really wasn't what some people were wanting. So an appeal was taken, and it was sent back. It didn't get to the Supreme Court, but it was sent back, and the arbitrator, again, was requested that perhaps he misunderstood his instructions. Okay, I made the argument the arbitrator acted beyond his authority because he didn't follow the instructions of the agreement. He went back, he re-examined everything again, and for a second time he determined that yes, indeed, the arbitration agreement at issue did permit class arbitration. So eventually that ends up in front of the Supreme Court as well. In that case, the court said, we are not called upon, nor could we, evaluate whether the arbitrator made a good decision. The only question we have is, did he make a decision? Not whether it was good, not whether it was bad, not whether it was in the scope. They had agreed that he could make a decision, and therefore whether his decision was good, bad, or ugly, the Supreme Court could not review it under the Federal Arbitration Review Rules. Bad decision by an arbitrator, you're going to be stuck with it. Be cautious who you agree to arbitrate on your behalf. But in that case, because the arbitrator made the decision that it was called for, the court never reached the issue of whether the agreement itself permitted such a determination. The court said it could not take a look at that question. Now we get to I don't know if I do so much, Tom, but from the seminar things that I'm getting, apparently these last two cases on arbitration are being viewed as a sea change. That arbitration or class actions are no longer going to be favored by the courts, and that arbitration, I think they're cutting back on what their scope of review is going to be. We're just going to decide, did you decide? What's the point of the appeal? Because obviously not. I think there is some changes, but I don't know that it's more than, I don't know that I can detect the direction. I think there's changes.
You detect whether people are moving away from including arbitration clauses in their contracts?
It is a more hotly debated topic. The question is, do we see people moving away from arbitration as a part of their contracts? And I guess for me personally, over the last several years, if I'm dealing with a case that's going to involve one of the reservations, we're sometimes okay with getting arbitration there because it allows the federal enforcement rules to be put into play. So for tribal-related matters, I'm seeing more of a lean towards including them. But on other state court proceedings, I guess I'm not personally seeing enough to say one way or the other. Is anybody else seeing it pushed to or away from arbitration? They're setting up their contracts. Yeah, I don't know that I'm actually seeing it, but I am in Indian law context seeing somewhat more of a direction, not just from my office, but elsewhere. It's hard, of course, to get a judgment against a tribe and actually enforce it. But if you've got a contractual agreement with the tribe that includes an arbitration provision and the agreement's properly adopted, and it does allow you to use the federal law to collect on the award from an arbitrator. I think it's an area that's going to have a lot of things going on. Arbitration, class action, I think there's going to be much going on with that. My car. Actually, this guy's car. And I don't know what appealed to me when I came across it. Whether it was just that it was a Civic, when it didn't turn out to be a Lamborghini or a great vehicle. or anything. But this car is the source of a lawsuit that actually made it to the U.S. Supreme Court. And it was a case of first impression at the U.S. Supreme Court. And it concerned a split of views among 2 or 3 state Supreme Courts as to what the proper ruling of law was. A bit of background. Mr. Pelkey's car was towed in 2009. So it's a 5-year-old car, 6 depending what type of guy. And the condo place that he was living had a requirement that if it snowed beyond a certain amount, you had to get your car in the garage and move it and couldn't stay there. Well, Mr. Pelkey at the time of this snowstorm was ill. And he was in his home there, in his unit, and was unaware of what was going on outside. He was apparently bedridden. His car was towed. Mr. Pelkey's life went downhill from there. The snowstorm let up, but his health deteriorated, and he was hospitalized. He was hospitalized for months. In the course of his hospitalization, whatever was going on, his left foot was amputated. He's still in the hospital, recovering from that, and he suffers a heart attack. This guy has had a really rough go for months. Eventually he's released, he gets back home, and he can't find his car. He calls his attorney, who checks around and discovers that his car had been towed back in February. Now it's April. His car had been towed, and he had not been notified of the fact that his car had been towed. His attorney found out where the car was. This case is on page 3, if I didn't say it. His attorney discovered that the car had been towed by this towing company, Dan City Used Cars. They had towed it, and then they had stored it, and the car was going to be auctioned 2 days after the attorney contacted him. The attorney contacted Mr. Pelkey, who said, I want my car, I'll pay the storage fees, give me my car back. The attorney did make the call. And at that point, the attorney was lied to by the guys in Dan City who said that the car had already been sold. Well, the auction took place, and we had that nice, beautiful car, only because I couldn't find a really great beat-up car. It's a car auction. Nobody bid on the car. I suspect that picture of the brand new 2004 car is not representative of what it looked like at the car auction, or somebody would have made an offer on the car. Well, eventually the towing company traded it off, but the end of the story was that Mr. Pelkey never got a dime. He never got his car, he never got any money, he never got any compensation. So he brought suit. Not entirely unreasonable. He tried to get his car, failed to get his car, so he sued. And he sued because they had not followed the New Hampshire rules on getting the storage fees, a lien paid. So, in an awesome display of lawyering, Dan City Used Cars filed the Federal Aviation Administration Act and said that preempted this lawsuit. Really? That's not exactly the first place I would have gone to see once if I could stop it. But that is part of the regulations that deregulated the trucking company, towing companies, and motor carriers under that. And so they alleged that you couldn't bring this suit because he was a motor carrier. The trial court agreed, it was preempted. New Hampshire said, no, wrong, it's not preempted. It went to the U.S. Supreme Court on that car, which probably was beat up and didn't exist. And the court said, no, it's not preempted. It's not in transportation. It's being stored. And I'm being told that you're done with me. And I have one more slide left, and you'll love to see it, so you are going to get to see it. In case I didn't have everything covered in my time. So we are finished. Did anybody have any questions on anything? If not, thank you.